Hello everyone, today's topic is search warrant under Criminal Procedure Code. A search warrant is an official document that gives police officer the authority to search a building for stolen property, illegal goods or information that might help to solve a crime. It is a court's order giving the police authority for the examination of a place for the purpose of discovering certain documents or other things necessary for investigation, inquiry, trial or other proceeding under the criminal law. Under the Code of Criminal Procedure 1973, for the purpose of ensuring fair investigation, inquiry, trial, or any other proceeding, it becomes necessary to require a person to produce a document or thing which may be in his possession or power and which may have a bearing in the case. This can be done by two ways: first, summon, and second, warrants. Moving forward to issue of search warrant. Under Section 93, Clause 1, a search warrant may be issued in the court in the three cases, which are: firstly, where any court has a reason to believe that a person to whom summons is issued will not or would not produce a document or things as required by such summon or requisition. Secondly, where the document or thing is not known to the court to be in the possession of any person. And lastly, where the court considers that any purpose under the code is served by the general search or inspection. The purpose to whom such warrant is issued may search or inspect in accordance with the provision in the code. The issue of the search warrant is an integral step in the procedure for investigation. A search warrant may be general or specific in its scope. The court may also issue a warrant when it is unaware not only for the person but also the place where the documents may be found and a general search becomes necessary. A magistrate has to record his reason for the issue of a search warrant. Necessary precautions need to be taken that the power vested with the officer are not abused. The constitutional validity of this section was challenged in the case of Pillai versus Ramakrishnan, where it was upheld and it was opined that a search of the premise occupied by the accused does not by any means result in compelling him to give evidence against himself and hence was not violative of Article 20, Clause 3 of the Constitution of India. Moving forward to the topic search of a place. If a magistrate upon information and after inquiry has a reason to believe that any place is used for the deposit or sale of any stolen article or any objectionable article like counterfeit coins, currency and or stamps, forged document, false seal, obscene objects referred in section 292 of IPC, may by warrant authorize a police officer not below the rank of constable under section 94 of the code to: first, enter if necessary such place; second, search the place; third, take possession of the stolen or objectionable article; fourth, convey the same to magistrate or keep the article safely; and fifth, take into custody every person found in the place as suspected and produce him before the magistrate. Now, search warrants for forfeited publications. When any newspaper, book or any document, painting, drawing, photograph or other visible representations where printed appears to the state government to contain any matter which is punishable under section 124A, which is sedition, 153A, which is prompting enmity between different group, 153B, imputation, assertion prejudicial to national integration, section 292, sale of obscene book, section 293, sale of obscene object to young persons, or section 295A, deliberate or malicious act intended to outrage religious feelings of IPC, declare every copy of such issue to be forfeited, and then the police officer may seize the same and the magistrate may issue a warrant and authorize any police officer to enter and search any premises for any copy of such issue under section 95 of the code. The state government, however, has to state its ground of opinion, and this section does not violate any guarantees of the Article 19 of the Constitution. However, an effective remedy is provided under section 96 that an order passed by the state government can be challenged in the High Court by a way of application within 2 months, in which case if High Court is satisfied may set aside the declaration of forfeiture. Every such application shall be heard and determined by a special bench of the High Court composed of 3 judges. Moving forward to topic search for person wrongfully confined. Section 97 comes into operation when the magistrate has reason to believe that any person is confined in such a way that the confinement may lead to an offence. Then a search warrant may be issued for the search of such person, and if found, such person shall be taken immediately to magistrate, who shall take further action. Compel restoration of abducted females. Where a woman or female minor has been abducted or unlawfully detained, a magistrate may restore her liability or the proper custody as per the power under Section 98 of the Code, and in restoring such possession, necessary force can be used. Search of a closed place. Under Section 100, when any place which is required to be searched or inspected is closed, then any person who is residing or is in charge of such closed place shall, on demand of the officer who has the search warrant, allow him free ingress and afford all reasonable facility for search. If entry into such place cannot be obtained, the officer may proceed in the manner provided under Section 47 Clause 2, that is, break open any door or window of any house or place. Subsection 3 provides for the search of a person in case such person is suspected of concealing about his person any article for which search is being made, and if such person is a woman, she will be searched by another woman with regard to decency. Before making a search, the officer shall call upon two or more independent and respectable inhabitants of the locality as witness to attend and witness the search. The witnesses are to be selected by the officer conducting the search, and they should be uninterested so as to ensure fair dealings, although the person called as a witness is required to attend the court unless called for. In the case of Mahesh Pal Singh versus Puran Singh Tiwari, it was held that if certain things have been recovered in a different district beyond the local jurisdiction of a court which issued the warrant, the things recovered have to be taken to the court which issued the warrant, so that the details of the case in the FIR might be ascertained and further investigation can be made as per Section 101. Now ending the topic, and the conclusion comes out of this topic is that Chapter 7 of the Criminal Procedure Code contains Section 91 to 101 provides for the previous related to search warrant and other general provision relating to searches, that is, the issue of warrant, execution, power and procedure. All these sections ensure a free, fair and just investigation, inquiry and trial of a criminal case in order to provide justice. The officer executing such warrant should comply with all the statutory requirements provided in order to ensure the objective of the code. Thank you so much.